好，欢迎大家回来。接下来，让我们进入到议题2环节：政治和法律视角下的南海历史。让我们有请主持人外交部原副部长乐玉成。乐部长，有请。
我就不上台了啊，我就在这里主持。这个尊敬的四川院长还有郑市长，大家上午好。我是也很荣幸的这个参加这次活动南海活动，主持第2议题的讨论。我先声明，我不是这方面的专家，在座的专家都是这个长期搞南海问题的研究的。但是呢，我在过去几十年的外交生涯中也经常碰到南海问题，也参与了呢有关政策的南海问题的这个政策的分析和应对，因此呢，对南海问题的复杂性、重要性这个还是有所了解。咱们这个议题呢是政治和法律视角下的南海历史。说到历史问题刚才吴世成院长在开幕致辞中开门见山那就指出，南海历史有一个基本的事实，那就是中国人民始终是南海诸岛的主人，并且是唯一的主人。我非常这个支持这个吴院长的这个判断。中国的确是最早发现、命名和开发利用南海诸岛及相关的海域。历史表明，早在2000多年前的西汉时期，中国人民就在南海活动。明清时期中国渔民已经遍布南海诸岛生产作业。南海大量考古文物也证明世代中国人在此定居生产。20世纪30年代前，国际上对中国南海诸岛的主权状况是没有争议的这一点刚才上午这个许多法律专家都指出了这个事实。世界上有不少地图和百科全书也都表明这个南沙群岛属于中国。刚才这个我们李国强院长也通过历史故事讲述了中国与南海的历史渊源和友好交往。这些年来，围绕南海问题，个别周边国家借助域外势力支持，通过各种手段刻意模糊历史脉络，曲解国际法规则，制造各种谬论和谣言，企图混淆视听，削弱中国在南海的正当主张与国际认知的基础。中方对此是坚决反对。我们今天的研讨会就是要通过厘清南海问题的历史演进与现实问题，正本清源，明辨是非，去伪成真，增进沟通与理解，维护南海的和平与稳定。中国在南海问题的立场是坚定而明确的，而且多少年来一以贯之，那就是坚定地维护国家领土主权，坚定维护地区和平与稳定，坚持通过同直接当事国友好协商谈判和平解决争议，同时和东盟共同维护南海的和平稳定。我们这一个参与研讨的有7位专家我看了一下名单，这个代表性还是很广的既有中国人，也有境外的人士学者，既有域内的，也有域外的，既有国际政治专家，也有国际法等其他方面的专家。还有不少我的前同事这个同事外交部的大使。这个我想，这个我们代表的广泛性可以多视角的来把脉南海历史问题。好，我下面就请这个我们专家开始发言。首先我们请印尼战略与国际研究中心副主任 索菲亚这个莫西巴克，谢谢 ，please。
Thank you so much, moderator, for that introduction. First of all, a vote of thanks to the organizers for the invitation and hospitality. Really an honor to be here and be part of this very important event. I'm not a legal expert, so I will leave that part to my other panelists and focus more on the political discussion. And even that, I think we are covering a broad range of issues. So to take advantage of coming from Indonesia, officially a non-claimant state, I will focus my short remarks giving such perspective. I will begin with this quote from Indonesia's former foreign minister, Martin Natalegawa, from 2014. So that was 11 years ago. He said, "Indonesia is not a claimant state in the South China Sea dispute, but we have a vital interest in ensuring that the area does not become a source of conflict." I think this short statement truly represents the core of how Indonesia views the South China Sea dispute. A very short statement, yet to understand the statement, we also need to take a look at the historical evolution of the South China Sea itself, not merely as a space of geopolitical tension as we see it now, but one shaped by layered usage, shifting maps, and evolving international law. As elaborated by Dr. Wu's opening remarks and also discussed in the previous panel, the history of South China Sea goes back hundreds of years. For Indonesia, it does go back hundreds of years for us as well. And we tend to put this history into 4 periods, at least. The first one is, of course, the pre-colonial era. For centuries, the South China Sea functioned less as a frontier and more as a fluid, interconnected maritime highway. Long before the concept of nation states, the waters were crisscrossed by merchants, seafarers, and pilgrims from everywhere, including the Malay archipelago, China, India, and beyond. For Indonesia, we see it as the sea where the Sriwijaya, Majapahit, and other Indonesian archipelagic kingdoms maintain expansive maritime trade networks across the South China Sea. These waters at the time were never subject to strict national boundaries. Instead, they were governed by customary usage, regional influence, and overlapping spheres of tribute and trade. So Indonesia's historical relationship with the South China Sea was never about territorial ownership, but about mobility, about exchange, and about coexistence. The second period is, of course, the colonial imposition and the birth of borders. The arrival of European colonial powers, particularly for us, was the Dutch, and then the British, Spanish, and French, introduced a different way of organizing maritime space. Colonial cartography began imposing fixed boundaries and maritime jurisdictions. For our ancestors, that was something completely new. We never understood anything about fixed boundaries, and we were never familiar with maritime jurisdictions. In Indonesia's case, Dutch colonial administration never extended any claim over Spratly or Paracel Islands, nor did it ever define the South China Sea in geopolitical terms. So that's how we understand it from Indonesia's point of view. However, Indonesia's maritime archipelagic identity as a state connected by sea was deeply shaped by this colonial legacy of both fragmented rule and maritime control. After that, we came to the third period, which is the post-colonial claims. And I think this was hugely discussed in the previous panel, so I'm not going to go into deep discussion. But basically, the seeds of modern maritime dispute were planted after World War II, with countries starting to propose and assert claims of the territory. From Jakarta's perspective, this was an imported dispute, something that is created by others, but gradually encroaching upon Indonesia's maritime rights. From there, we come to the fourth period, which is Indonesia's post-independence legal foundations. And as an archipelagic country, of course, maritime issue is our core issue. It's our survival, basically. So if we don't have anything to define ourselves as an archipelagic state, then basically Indonesia has nothing as a state. So after independence in 1945, the young republic had to clarify its maritime boundaries, not just to assert sovereignty, but most of all, and I underline this, most of all, to unite a sprawling archipelago of over 17,000 islands. And that is, for us, our core identity. So in 1957, Indonesia introduced the Juanda Declaration, which laid the foundation for the concept of an archipelagic state, a principle later codified in the 1982 United Nations Convention of the Law of the Sea on UNCLOS as we know it now. So Indonesia actively contributed to the formation of UNCLOS and its maritime zones, including the definition of EEZ and territorial seas, and legally recognized under this regime. So from Jakarta's point of view, any claim that contradicts UNCLOS is basically illegitimate. We fought for the foundation of UNCLOS and we remain recognizing the importance of UNCLOS. So while Indonesia had no historical claims to the Spratlys or Paracels, it found itself increasingly entangled in a dispute that basically we never asked to join, simply because it stood by the principles of international law. So how do we understand this? How do we understand Indonesia's involvement in the South China Sea? Back to the first claim that we were never basically a claimant state. So historically, Indonesia has avoided a militarized approach to the South China Sea. It has never pursued a confrontational claim to rocks or reefs, nor has it sought to challenge others through force. So instead, Indonesia's posture historically has, 1, to uphold freedom of navigation, 2, to champion the rules-based maritime order, and 3, to ensure that any claims that do not override international law. So with this in mind, we move on to the next phase of history. So after the claims, after UNCLOS, and looking at the beginning of the rising tension in the South China Sea. So back to the quote from our former foreign minister, Indonesia has a vital interest in ensuring that the area does not become a source of conflict. So in the late 1980s, it was becoming very clear that something had to be done. And I think for Indonesia, this gave way to the ideas of starting initiatives, and this is where the workshop on managing potential conflict in the South China Sea began, and also, basically laying out the foundation of Indonesia's involvement in managing the disputes in the South China Sea. The workshop itself was launched in 1990, a period of rising tensions and the clear need for dialogue, which was lacking at the time. Indonesia's vision was for this workshop to be a proactive and visionary step to de-escalate tension before they escalated further. Crucially, the workshop is, of course, as we know it, is informal and non-binding. But then at the time, mind you, this is again the beginning of the 1990s, this was a strength. It allowed participants to engage freely without the pressure of formal declarations or legal commitments, fostering a more open environment. For the participants, it brought together claimant and non-claimant states, including academics and experts, and this broad participation was a key. The objective was first, of course, fostering open dialogue, and then building trust and confidence, and exploring practical and non-political areas of cooperation. The last part was particularly interesting because I think with this workshop was the beginning of discussions regarding the practical cooperation, so beyond politics. We might be familiar with it now. There are plenty of discussion on these issues at the moment, on marine scientific research, on safety of navigation and communication, on environment protection, on search and rescue. But I think we go back to the beginning of 1990s, that was mostly unheard of, and this workshop was the beginning of the discussions on these issues. So why did this matter? These practical collaborations, I think while seemingly small, build habits of cooperation and mutual understanding, creating a foundation for addressing more contentious issues in the future. So with these different settings in history, up to the 1990s, there are questions about the relevance now. Of course, if you look at the current geopolitical tensions, such a workshop is no longer relevant. We can no longer benefit from merely dialogue, merely talk shop, and we need to move on to more practical cooperation. But ideas to revive the workshop, of course, has to begin with realistically the situation is now different, a lot more complex. But then again, I think this workshop still laid the groundwork. It's not a direct conflict resolution mechanism, but lays the essential groundwork for future comprehensive and peaceful resolutions. And with this, what we basically I can key takeaways from some of the Indonesia's involvement in managing the South China Sea dispute. There are a lot still to do, a lot of homework, definitely, but Indonesia's position basically never changed. Back to Martina Talagawa's quote, is still a vital interest for us, and I underline that Indonesia's interest is basically so that it doesn't become a source of conflict. Again, reiterating the power of informal diplomacy, sustained dialogue, and focusing on practical cooperation. I'll stop here, and I look forward to further discussion. Thank you.
好，谢谢索菲亚主任。我觉得他刚才比较清楚地阐述了印尼在这个南海问题上的一些主张和立场。据我所知这个我们中印尼之间也不存在岛礁这个归属的问题的争议这是在海洋划界一个海洋权益方面有一些分歧。而且刚才也讲到了。 他也讲到了，印尼是主张通过对话通过外交、政治手段解决这个推动这个各方进行沟通，不要搞军事对抗。我觉得这些立场都是非常积极的吧，积极的。我想通过这也是和中方立场是吻合的，就是我们要通过对话来这个解决分歧，维护地区的稳定。 好，下面我们请这个台湾政治大学台湾安全研究中心主任刘富国先生发言。You have the floor.
Thank you so much with this particular honor to be able to speak in this very timely and important session. From this morning, we have heard Dr. Wu Sichun really gave such a broader landscape of the discussion. Basically, the discussion has been very much on the historic basis, and I think my job here as one of the panelists, I am focusing more on political dimension. Looking back from the issue beginning, this is the main point I want to share, how we should really look into this South China Sea issue. Briefly, looking into political history, this is a very complex mix of colonial legacies, post-war treaties, strategic rivalry, and shifting power dynamics. Almost every element aiding on this South China Sea dispute, and previous session already focused on more on the historic part. But basically, it reflects such a complicated issue. Today, we are facing with different set of history. The history before 1982, UNCLOS signed, and also thereafter, after 1982, the issue really lingering on. Many issue and also disputes happens after 1982. As you can tell, the main narratives focus more on the arguments on the UNCLOS. So based on this legal discussion, and it emphasizes all these difficulties moving on. So my presentation will really quickly run through the earlier part and also come to what we should be facing today. And it tells the main thrust of this issue. Just a look into pre-20th century, 20th centuries, all the claimants come with its own story and historic background. So we are telling this particular history, China from very early time. We already have such a clear records of activity in the South China Sea. But interestingly, if you look into Vietnam, the Philippines, Malaysia, they also come with their own shorter history relevant to the South China Sea. But all in all, this is the real historic development. You cannot change it, but I think today, every one of the claimants comes with their own story. Very interesting, but more complicated is during this colonial influence, we have a French influence and also British influence in the region. Later on, Japanese colonial also come over this particular part. And after these post-World War II orders from China's 11-dash lines to 9-dash lines. So just to run through quickly, 1947, 1949 to 1980s, geopolitical uncertainties and also emerging claims gradually mixed up in the region. More and more, I personally observe the real issues comes with main two factors. One is newly independent regional country coming up and looking into their rights in the ocean. But the other possibility is 1982 UNCLOS really gives a regional country, littoral state, with more rights to claim. So these are all clashing together. But of course, looking back from 1974 to almost 2010, there are some particular issue happening. China especially began island building and deploy naval patrols in the region. But of course, China is not alone. The Philippines and also Malaysia, Vietnam follow through. This is the newly competitive situation here. So basically, as I can see, legal confrontation and political controversy, 2013, this arbitration case came into the picture. And as I can tell, the significant point is all the discussion, as you can hear, the Western narratives focus much more on the legal dimension. Whether there is a historic development, they really did not emphasize. They only fall onto UNCLOS, the legal dimension. I don't think this is quite sufficient. The way to find a way to resolve South China Sea maritime dispute here, because if you are talking about legal issue, then it comes with who has the legitimate right to interpret UNCLOS. So this may be something interesting. Whoever owns these dominant narratives in the global public opinions, obviously they have such a priority to interpret such UNCLOS. So then we come with this different interpretation and also competing this statement. But this is exactly what we are looking into. So regional resistance, Southeast Asian states, especially the Philippines, Vietnam, increasingly pushing back with legal, diplomatic, and military tools vis-à-vis China. And India, Japan, Australia, and Europe thereafter gradually also join to exercise such rule-based international orders in the region. But whenever the situation happens there, it is quite ironical, especially we are talking about the issue in 2025. And looking into the main source of this argument coming from the United States, why the United States government today is not really following the so-called rule-based international orders. I believe many of regional players, looking back in the last 6 months also, already failed very critically. President Donald Trump in particular does not really follow such rule-based international orders here. So basically, political themes combining with South China Sea dispute, I made this into 4 categories. You can make this themes: sovereignty versus maritime law. And I remember not long ago, before our dear friend, late Ambassador Hashim Jalal was still alive, one day, just before 2010, we discussed such a great concern in the South China Sea. And he said that before the first country, Vietnam, regulate domestically, becoming their domestic maritime law. And before that, it was much easier for regional players to discuss and trying to find a accommodated room. But thereafter, almost all claimants start regulating through their domestic legislation. So then this is a difficulty because sovereignty is quite a controversy in the South China Sea, while many claimants already regulate through their domestic law, making the issue even much more difficult to move any further and becoming competing interpretation for their rights under UNCLOS. So I don't think this is something interesting to say that criticizing each other who is the right or wrong, because different interpretation is much more difficult to go through. But at this moment, power projection, as I can tell, China, United States going through the power competition, and this is really, as I can see, overshadowing the South China Sea overall. But today, after President Joe Biden's administration, this bill has already becoming such a airlines competition. The United States has forced with this AUKUS and then Quad. And lately there is a saying this new formation is coming up as a Squad, possibly including the Philippines and the South Korea. So wrapping up my short presentation, there are probably 2 specific key to be mindful. The number one is throughout the short history of South China Sea, the main problem is all the direction of a dispute is driven by political or geopolitical direction, because under the table, whoever takes such a priority, then they would have their international interpretation about UNCLOS. Then it would drive the direction and also disputes further. This would be something every one of us would have to sit together and think the next step. And I remember from the first presentation today, already highlighted most of South China Sea issues are overshadowed by political issue, not really the legal dimension. I think simply going through UNCLOS legal regulation, it is not that difficult to find which way is right or wrong. The most difficult part is a political argument and articulation. So basically, my conclusion is we have to face up to competing legitimate interpretation by relevant country now. And that would be the key for us to face up to. So once again, I'd like to thank Dr. Wu Sichun for inviting me to this very meaningful discussion this year. Thank you.
谢谢刘福国主任啊，我看比较全面系统的梳理了这个南海问题的一些症结所在产生的原因呢，还有整个演变的过程他最后也得出了结论这个南海问题还是牵动着21世纪的这个国际大国政治包括这个军事各种因素吧。是一个不是一个简单的问题好，我们下面请这个武汉大学中国边界与海洋研究院教授雷小璐 ，please。
Thank you. And thank you for having me here in this great event. And today I want to share my personal opinion on the territorial sovereignty over Huangyan Dao. And first of all, I'd like to emphasize some of the ICJ jurisprudence on the sovereignty over the land or the maritime features. We all know that the colonial norms or the methodology is debated very frequently before the ICJ, but before the ICJ, they will need to deal with some of the land or the maritime features sovereignty. They will follow some of the jurisprudence. And the first thing will be the title and effectivities. To be very short, the legal title goes first, and then if none, the ICJ will go to examine the effectivities. This is the very first short conclusion. And what is the legal titles? I think this question has been discussed before the ICJ for many times, and the conclusion would be, first of all, you will have some documentary evidence, but it's not limited to the documentary evidence. You have other forms of evidence, and this conclusion is confirmed by a very recent case just published in May 2025 between Gabon and Equatorial Guinea, confirming this case. And we can make a summarize that the titles can be found in many forms, and the treaty as titles is the most important. And sometimes before the ICJ, titles could be based on some decisions of political organs or the previous awards. Some rulings relating to the succession of states could also imply to respect of the existing boundaries. And some unilateral conduct may lead to abandonment of sovereignty or transfer of that sovereignty. And so let's begin with the treaties relating to the territorial sovereignty of the Huangyan Dao. We all know there are 3 treaties to define the limits of the Philippine territory. And the China and the Philippines have different opinions on whether those 3 treaties have included the Huangyan Dao or not. And China believes that the 3 treaties and subsequent domestic legislations confirm that Philippine territory does not include Huangyan Dao, while the Philippines believe that, first of all, in its position paper, it says that the sovereignty does not rely on that treaties. But from the Justice Antonio Carpio's argument, he believes that the Huangyan Dao was settled under the 1900 treaty between Spain and the US. So let's see how to define or how to interpret that treaty to see whether the 1900 treaty involved Huangyan Dao or not. We'll see lots of the cases which interpret the treaties relating to the land territories. And first of all, we will go to the Nicaraguan Colombia case in 2012. The ICJ interpret whether some islands raised by the two states constitute part of the Honduras archipelago under the 1928 treaty, and it gives us a very high threshold. It called sufficient to clarify whether those maritime features as the composition of that archipelago. Both of the parties gives many of the historic documents, but the court says it's not sufficient. But how sufficient? I think the recent case will shed a light on this issue, because in the very recent case, when the 2 countries asked ICJ to identify the legal titles relating to the sovereignty of some islands, the ICJ definitely says that, this time the evidence is sufficient. And we can see that why it is sufficient. Because first of all, ICJ knows that the diplomatic correspondence between Spain and France in the colonial era clearly indicates that France recognized one of the islands constitute a natural natural dependency of the Korosko Island, which can be found in that treaty. And the court also notes that both of the parties, Spain, France, Spain, Gabon, and Guinea, Equatorial Guinea, agree that the three islands constitute a single unit, and France shares the same view. So it's very threshold, very typical, very special in this case, that this kind of argument and the logical could be considered as sufficient before the court. So we all know that if you want a court to make the extension of the sovereignty to the maritime features in Invincity, the evidence should be sufficient as a very high threshold. So let's see, it goes back to the 1900 treaty. I will see that the owning clause in that treaty, nothing relates to the Huangyan Dao. Nothing refers to the Huangyan Dao. And if you want to say that Huangyan Dao is involved in the Philippine archipelago, I think the threshold sufficient should be applied in this, and the evidence should be very sufficient to demonstrate Huangyan Dao can be constituted a part of the Philippine archipelago. And if we took into the terms and the circumstances when it concluded, we'll find that the main problem between the two countries at that moment is island of Cagayan and Sibutu. When 1898 treaties was concluded, the U.S. goes to the southern part of the Philippines, and the questions between the two parties when they concluded the second treaty is mainly about the two islands lies into the southern part of the Philippines that is also out of the treaty line in the Treaty of Paris. So that can be read from the letters between the Spanish minister and the U.S. secretary just before the conclusion of the second treaty. And thirdly, we'll see that in that letter, it reveals that America also knows that Spain cannot cede anything that it doesn't have title to the U.S. And this was reviewed by the clause of the 1900 treaty. So the essential point is that whether the land at the moment of conclusion of the Treaty of Paris within the Spanish territory. And we will to define whether the Huangyan Dao is within the territory of Spain. We'll look into the intertemporal principle laid by the island of Palmas case. It says that in 19th century, owning this cover alone cannot establish a title. So when we goes to the evidence listed by the Philippines, we'll see that this evidence is far from sufficient to make that argument established, because it only lists some of the survey, and all this kind of survey comes from various states, not only Spain, but also from Japan, the UK, and many of the countries. And the intention of those surveys are for navigation, because we all know that the British ships have some accident in the Scarborough Shoal at that moment. So from those, the only conclusion we can make that according to the three treaties, Spain did not have Huangyan Dao ceded to the USA by those treaties. Second, Huangyan Dao is not included within the Philippines territory. And after the World War II, I think it's a very quite important time in 1948. And before that, neither the Philippines or the USA have made an official claim to the Huangyan Dao. We can see from some of the letters between the Commonwealth of the Philippines and the US. In 1938, None of them knew the ownership about Huang Yuandao. They have no information about the ownership of Huang. It's very hard to imagine that if a country has a claim to sovereignty, has no information about the ownership of that island. So this demonstrates that they do not have anything to any official claim before the 1948 at that time. But while China has made very clear, very sure, 100% sure that Huang Yuandao is within China's territory, is China's. In 1935, China published a list of 132 names of the island and other insular features in the South China Sea. And this was repeated, retreated in 1947. And the Huang Yuandao is listed there. You can see this from Nansha Chuna, but at that moment, Zhongsha Chuna called Nansha Chuna, Nansha Chuna called Tuansha Chuna. So I think it's quite consistent with our claims here. So if we make a conclusion at this time, there was no competing claims in the Huang Yuandao before 1948. So China can establish very confirmly the title over Huang Yuandao by exercising its authority. So Huang Yuandao is not it's not a terra nullius in 1946, and it was China's territory. And after the okay, I'll make a conclusion. I'll make a final conclusion. First of all, the treaties does not cede Huang Yuandao to anybody, because Huang Yuandao is never the territory of Spain and the Philippines. And secondly, from the from the time to time, we see that not until 1997, the Philippines does not or did not or has not make any official claims to the sovereignty of Huang Yuandao. And China has established its title over Huang Yuandao through its authority exercising from the very time immemorial, and the authority administration by the ROK and PRC. So it's my final conclusion. Thank you.
好，谢谢小陆教授啊，这个从历史法理的角度非常细致的分析了黄岩岛的这个问题的来龙去脉，而且有充分的法理依据吧啊，证明黄岩岛是中国的领土。无论是1898年的巴黎条约，还是1900年的华盛顿条约，都不支持啊这个黄岩岛构成啊这个菲律宾领土的一部分。所以我觉得事实讲得很清楚，谢谢谢谢。好，下面我们请这个德国公法和国际法这个马克思普朗克比较研究所研究员Christian Schohes，please， 谢谢。
Well, let me begin by thanking the organizers for the kind invitation to join this workshop. So my presentation is about identifying conditions for cooperation and conflict management in the South China Sea. When we look at the South China Sea today, we are able to observe its current developments with the benefit of the experience made over many decades. So this presentation seeks to identify lessons that we can draw from the past 30 years of efforts that were made to reach arrangements for natural resource cooperation and conflict management in the South China Sea. This presentation is based on my recent book. It was published last year. It has received some praise, but of course, I would be curious to learn whether you also think it is a good book. So what is the book about? After more than 30 years of negotiations and efforts to reach arrangements in the South China Sea, it is time to ask a straightforward question. Why have states in the East and South China Sea reached agreements for oil and gas and fisheries and conflict behavior in some cases, but not in others? Now, this map on the left-hand side illustrates fisheries agreements in the East China Sea. So I believe, or my book shows, that of all arrangements in the East China Sea and South China Sea, these arrangements are the most effective in preventing incidents. They are essential elements for stability in East Asia. Without these arrangements, a stormy period could be expected. How do these agreements achieve this? Well, they define different subzones. They define a different set of carefully adjusted rules about behavior of fishing boats and coast guards in each subzone. And as a side note, there's also a fisheries subzone in the southern part of the East China Sea. This is absent from early publications. Therefore, it's lacking here on the map. Even in one of the expired zones, like the TSET, the Sino-Korea TSET, is a transitional zone in the Yellow Sea. This is an area where frequent and perhaps even rampant violations of the agreements have occurred. So these violations of the agreement led to clashes, killing Coast Guards, personnel of Korea, and Chinese fishermen. Nevertheless, the agreement is important because the agreement prevented that deadly incidents escalate at the interstate level. Now imagine what would happen in the South China Sea if the Philippines were to enforce their rules with the machine gun. Well, in the Yellow Sea, the Korea Coast Guard did enforce joint Sino-Korean rules with machine guns, and most people in the world haven't even noticed. The reason for this is there's no attention on the Yellow Sea. The reason is that these agreements take the most sensitive issues off the table, namely the competing claims. In contrast, in the South China Sea, there's hardly a week without an incident. I am, of course, not the first to observe that these agreements are important. And in the past 30 years or so, there have been many attempts to reach similar arrangements. Here, a screenshot from the consultations between former Undersecretary Severino and Vice Minister Wang Yingfang in the 1990s. Now, these consultations resulted in a working group. Philippine and Chinese officials discussed many models for close to a decade without tangible results. So what explains this variation between agreement and impasse? Now, thankfully, in this room, most people will know the cases, and no long overview is necessary. I will just mention a few examples. Here, the Philippine experience with the Joint Marine Seismic Undertaking, an arrangement applying to a part of the Spratly Islands. So what was the Philippine experience? So the JMSU, it started, in the words of former President Arroyo, as a, in quote, breakthrough for peace. Why? Because it is the only arrangement so far that applied to the Spratly Islands. So, but what started as a breakthrough for peace ended as a violation of the Philippine constitution that in the Philippine experience contributed to creating China's claim. So what are the problems with the agreement? There are three. The JMSU, in the eyes of the Philippines, validated China's claims to areas where China has little legal maritime entitlement. Second, China's claim hardened as a result of the arrangement. And third, according to the Supreme Court of the Philippines, handing over data to CNOC in the process of this arrangement weakened the Philippines' position, but strengthened China's position. So without going into any more details, here's a little overview over the negotiation behavior over the past 30 years. So some things are pretty straightforward. Actor 1 and 2 negotiate an agreement. The benefits of cooperative arrangement and conflict management are intuitive and straightforward. Tension-free access to natural resources, reduction of escalatory risk, separation of maritime issues from great power competition. However, negotiators are also aware that cooperation can result in factual vulnerabilities for a claimant. So in many cases, negotiators feared, or they learned the hard way, as the Philippines did, that the cooperative agreement enhances a rival bargaining power, but increases their own one. For instance, when arrangement entails a de facto validation of a rival claim, where joint activities reveal strategically relevant information, where they are used to consolidate unilateral advancement, and in other cases. So the key question then is how to protect against these effects. how to reach an arrangement that provides many of the cooperative benefits without as well reaching its perils. So, and many negotiations in the past 30 years were bedeviled by trying to exclude these perils while still reaching meaningful terms. I have two more examples. One here is from Philippine-Sino exchanges on joint development. So we can expect that after the Philippines' experience with the JMESU, the Philippines would no longer be interested in common energy activities with China. However, this is not the case. In 2012, negotiations resumed. What we can observe in these exchanges here between Deng Zhonghua and Bensurto and Nasuke is that there's a big difference between practical joint natural resource activities under international law and joint practical natural resources arrangements under Philippine law. This difference blocked the negotiations between China and the Philippines, and then they blocked it again after the South China Sea arbitration, when to the surprise of many, President Duterte was open to give Chinese energy companies access to natural resources in areas beyond the normal UNCLOS-based entitlements. So what you can see here is both sides are in principle open to practical natural resource projects, even in areas to which China has no maritime entitlement pursuant to the South China Sea arbitration. But both sides feared that the other side's proposal is a vulnerability for their claims, and so they couldn't reach on an agreement. This problem does not only apply to the Philippines, it also applies to China. Here I have the memo of China's position regarding the first ASEAN draft code of conduct. So let's look at the problem in point B. So what's the problem with refrain from inhabiting presently uninhabited structures? One might say that not inhabiting uninhabited islands is a useful provision for a code of conduct, because this is among the most escalatory behavior in these disputes. So one problem with that provision was that Southeast Asian claimants had already built their structures, whereas Chinese structures were relatively small at the time. So Chinese negotiators most likely saw this as an attempt to deny this option to China. So we can see Philippines has a problem with concrete, practical agreements that appear very useful, intuitively straightforward logic in favor of cooperation. Such arrangements result in vulnerabilities. This is the position China also had here, for instance. In this case, and there are many more cases that you can find in my book. Final slides. So, what is lacking to move forward with maritime cooperation in South China Sea? Is there a way out? First point is to take seriously the experience of claimants that cooperation can result in an extension of rival bargaining power and presence. This is a major barrier to any arrangement. This problem does not only apply to smaller countries in their negotiation with China, so to Southeast Asian countries vis-à-vis China, it also applies to China vis-à-vis Southeast Asian countries. It even applies to cases excluding China. So the negotiations between Brunei and Malaysia, or Japan and Korea, or the Philippines and Taiwan, they also had this problem. Sometimes they found a solution, sometimes they didn't. Second, there are two ways to address it. One is more technical and the other is more political. Both are needed. We can see that the design of the fisheries agreements in the East China Sea, so I showed you the map at the beginning, that in each subzone we have different different terms. So here the design of the agreements designs of these agreements have responded to this problem in a very technical way, but then the political is also important, and here the political is that Southeast Asian countries do not currently have the expectation that cooperative arrangements with China will satisfy China's claims and reduce China's pressure. So they look at every draft agreement and ask, could it advance China's claims? The prediction is therefore, the better China diffuses this expectation, the more willing Southeast Asian countries are to cooperate with China. Two questions are therefore, to what extent would China reduce pressure on Southeast Asian claimants if China and Southeast Asian states were to cooperate in specific maritime issue areas? And second, to what extent could China accept unilateral activities of Southeast Asian states in their EEZs and continental shelf if they were to consent to resource sharing activity? To my knowledge, from a perspective of Southeast Asian capitals, these questions are left unanswered. So therefore, shelving dispute developing jointly is incomplete. Specific commitments and assurances answering the two questions are lacking. And if you're interested in more details about these suggestions or about the negotiation process, please have a look at my book. Thank you very much.
好，谢谢索尔海斯教授。我觉得他讲了很多关于如何这个避免南海地区的冲突，这个加强呢危机的管理和这个促进合作，还提出了他的一系列的想法和建议，特别是要看他这本书。好的，谢谢。我们下面这个请郑志华教授上海交通大学日本研究中心副教授。好，谢谢。
谢谢乐部长。首先也允许我这个跟前面的发言人一样，这个感谢组织方中国南海研究院跟华研海洋研究中心特别是这个吴院长的邀请，有机会跟大家学习跟分享我的一些这个研究。因为我这个 PPT 是用这个英文准备的，所以我还是用英文的，按照原来的这个准备的发言吧The topic is about why the South China Sea arbitration ruling is a misguided exercise in legal colonialism. Why do I ask this kind of question? I want to put the ruling in a more broader context from the history perspective, also including the civilization and culture perspective to understand the ruling. What's the essence of the ruling, and why do we look in that way? And where shall we go next? As we know, 9 years has been passed since the arbitral tribunal issued its award on South China Sea on July 12, 2016. But far from resolving the dispute, the ruling has intensified the division, both in legal interpretation and geopolitical trust. From the Philippines and its Western airlines, the ruling was hailed as a champion of the rule-based international order. Yet for China, the award represents something far from problematic, a legal instrument cloaked in neutrality, but rooted in a Eurocentric vision of international law. Rather than paving a path to peace settlement, the ruling has undermined the credibility of legal mechanisms under the United Nations Convention on the Law of the Sea, exactly the regional tension and entrenching mistrust. When I was thinking the essence of South China Sea arbitration ruling, the philosophical underpin of the ruling, which respect a latent civilization hierarchy. The tribunal deems China's claim based on historical right incompatible with the model international law, effectively dismiss the century of maritime history as irrelevant or obsolete. In doing so, it privileged one model of legal reasoning, Western, non-Westphalia sovereignty over diverse historical experience. Yet history in East Asia does not conform neatly to Westphalia template. Pre-modern China and the Southeast Asia society interacted with the sea through not through exclusive territorial sovereignty, but through trade, kinship, fishing, and customary practice. Historical record and maps consistently show that China exercised a long-standing presence and influence over features and sea routes in the South China Sea. These are expressions of a different but no less legal consciousness, one rooted in economic use and continued presence, and also cultural connection. To reject these rights as non-legal is to impose a singular, Western-centric framework and to delegitimize alternative narrative of maritime order. The ruling then does not merely resolve a legal question, it affirms a normative hierarchy that marginalizes the perspective of non-Western state. And even, I think, the double standard and the political of selective legality is even more worse. The implicit hierarchy becomes especially clear when one examines the state practice, the tribunal interpretation of UNCLOS Article 121, paragraph 3, which my colleague will give a detailed presentation this afternoon. Those features unable to sustain human habitation or economic life are not entitled to exclusive economic zone, are applied strictly to China maritime feature. Yet major Western power continue to maintain sweeping EEZ and continental shelf claim from small uninhabited feature. For example, which is a land area of just 0.012 square kilometer, and Australia continued assault maritime claim from Middleton Reef, a low tide elevation, where Japan maintained over 400 square kilometer of marine entitlement based on Okitorishima. So none of these states has adjusted their claim to align with the standard they advocate in the South China Sea. This disparity betrays a logic of selective legality, where rules apply differently depending on who is subject to them. The inconsistency is not merely technical, it reflects a deep unwillingness to confront the colonial legacy embedded in modern law of the sea. At the heart of the controversial lies the issue of consent. A fundamental principle of international dispute resolution. China refused to participate in the proceeding, has explicited and granted in Article 298 of the UNCLOS, which permitted the state to exclude certain category of dispute, including those involving territorial sovereignty and maritime delimitation. Despite this, the tribunal process ahead, it ruled on the matter tied to sovereignty over feature in the South China Sea issue falling outside the tribunal jurisdiction under the convention. By invoking competence, the power of the tribunal to determine of its own jurisdiction, the panel effectively granted itself the authority to the rule on the matter that the tribunal on the UNCLOS has meant to address. This procedure overreach, regardless of intent, set a trouble precedent that jeopardized the convention's integrity and weakened its capacity as a consensual legal framework. The first point I would like to highlight the legal instrument cannot replace the historic dialogue. We all have a lot of puzzle, including the domestic and abroad. What's the essence of the Nine Dash Line? In my understanding, the essence of the line is a form of self-defense based on the concept of Westphalia boundary, which was developed in the Europe. It is like Chinese wine in Western Balkan. The meaning of 9-line cannot fully explain by use the terminology of the Westphalia system alone. The traditional Chinese practice and the logic shall be taken into account. So it is often said that the international must be blind to history, but the law does not operate in a vacuum. When deployed without regard to historic context or cultural background, the legal instrument can reinforce inequality. They purported to collect. The tribunal dismissed China's historic claim as legally irrelevant, ignores the regional long, complex maritime history, and within it lies the reality of the community who has navigated, fishing, and settled in this water for generations. By excluding such a narrative, the ruling inadvertently privileged maritime entitlement, born of colonial conquer over those rooted in organic historic practice. It fails to recognize the peace in the South China Sea will not be achieved by legal fate, but a mutual recognition of history, rights, and the lived experience. So my presentation, how to toward a more inclusive maritime order. The 2016 arbitration ruling has not strengthened the UNCLOS as intended. It fractured interpretation, weakens faith in dispute mechanism, hardened position. More fundamentally, it reveals the urgent need to evaluate the university of international law in an era no longer dominated by single civilization or legal tradition. In a multipolar world, legal legitimacy must be built on dialogue, not on imposition. South China Sea dispute is not simply a test of maritime law. It is a test whether international law can evolve beyond its colonial, Eurocentric foundation to accommodate a genuine, pluralistic global order. Under international law, can meaningfully engage with the history, value of all civilization. Its risk remain what it once was, a tool of power disguised as a promise of justice. Thank you for your attention.
谢谢郑志华教授，我觉得他讲的很围绕这个仲裁案呢，他提了很多新的观点啊，就是要走出西方那种法律真民主义啊，要尊重这个多样文明，这个主张通过对话而不是这种强加的方式吧来解决问题。总而言之，就多极世界需要一个多样的法律的体系或者秩序。我觉得这个下午还要继续的有一个 session 专门讲这个仲裁案的我讲这个很重要。好，下面呢我们有一个线上的这个请到菲律宾国际法专家这个做一个线上的发言，梅丽莎这个罗亚 ，please you have the floor。
Thank you for the kind introduction. Greetings to everyone, especially to my mentor, Professor Carty. My presentation is entitled The Spratly Islands as an Offshore Archipelago from a Historical and Comparative Perspective. Now, this paper or this presentation is only a subsection of a research project that I did for University of Copenhagen, which is the folly of a rules-based international order in the South China Sea. And so the presentation will focus on the historical and comparative perspective on the issue of offshore archipelagos. Next slide, please. I shall make three main points in the next 10 minutes. And the first main point is that there is need to focus on a specific dimension of the dispute on whether the Spratly Islands is indeed an offshore archipelago. And overlaying this, of course, is the more important issue about the concept of offshore archipelago. The second main point that I shall be making is that the issue of whether there are offshore archipelagos and whether the Spratly Islands is an offshore archipelago was not settled by the ruling of the arbitral tribunal in the South China Sea arbitration. The third main point that I shall make is that the issue is far broader in the sense that it has to be approached from a historical and comparative perspective on offshore archipelagos in particular. Next slide, please. Now, the focus on the issue of offshore archipelago necessitates a preliminary definition of offshore archipelago. And the definition that I adopt here is different from what is known popularly as a coastal archipelago in the sense that, in the sense that the archipelago I am referring to here is one that is distant from the 12 nautical mile of any state. And in particular, the Spratly Islands, of course, is more than 12 nautical miles from any of the claimants. Now, nonetheless, since the beginning of, not just the beginning of the dispute, but since the beginning of any discourse on the Spratly Islands, China, Vietnam, and the Philippines claimed the Spratly Islands as an offshore archipelago. And this was the case before the arbitration, at the time of the initiation of the arbitration, during the arbitration, and after the arbitration. And this is detailed in my paper, which is forthcoming. Now, the more important definition of the Spratly Islands as an offshore archipelago is in the law adopted by the Philippines in 1978, in the sense that the Philippines defined straight boundaries enclosing an area in the Spratly Islands and declared that that particular area, including the waters within, the seabed, and even the continental margin within, as part of Philippine territory. Now, this particular definition of the Calayan Island Group was not disclosed to the arbitral tribunal. The copy of PD 1596, the law in question, was not given to the arbitral tribunal. Nonetheless, of course, the arbitral tribunal should have exercised its obligation to ascertain every fact that is put forward before it. But in this particular case, it failed to do so. But the main point here only is that at the time of the arbitration, during the arbitration, and after the arbitration, all these states were claiming the Spratly Islands as an offshore archipelago. Next slide, please. Now, I say that the issue of the Spratly Islands as an offshore archipelago, or the issue of offshore archipelagos, was never resolved by the arbitral tribunal, despite its ruling. Now, one particular ruling of the arbitral tribunal is that it acknowledged that there are existing claims to the Spratly Islands as an offshore archipelago. It did cite the Calayan Island Group of the Philippines, but it did not adopt or refer to the definition of the Calayan Island Group. Now, at the same time, the arbitral tribunal declared that it has no jurisdiction. Yet, in its ruling under paragraph 573 to 576, the arbitral tribunal declared that no continental state like China or Vietnam, nor the Philippines as an archipelagic state, has the right to enclose the Spratly Islands as an offshore archipelago. In effect, the arbitral tribunal altered the nature of the territorial dispute. Now, the rationale of the arbitral tribunal is that Articles 7, 46, and 47 do not permit the constitution of an offshore archipelago. In fact, under UNCLOS, there can be no offshore archipelago under customary international law. Now, this is, I contrast this to the ICJ ruling in Nicaragua versus Colombia, where the ICJ declared that the San Andres Archipelago, which belongs to Colombia, a continental state, should be preserved. And the reasoning adopted by the ICJ in that case was that first, the limitation should be for the purpose of preserving public order of the oceans. Second, the breaking up of San Andres Archipelago would result in the breakdown of public order, in that certain areas of the archipelago will be interspersed with the Nicaraguan EEZ and continental shelf. And therefore, it anticipated that any such breakup of the archipelago would result in the breakdown of law and order in that area of the ocean. Now, that is exactly what is happening in the Philippines or in the South China Sea today, where much of the dispute, much of the turbulence, the geopolitical turbulence, arises from the fact that there is no way by which states or the claimant states could ascertain where the territorial sea of each pocket of territorial sea of each rock would end and where the Philippine and continental shelf would begin. And that makes the issue about the South China Sea or the Spratly Islands as an offshore archipelago still persistent. Next slide, please. No. Okay. No, in my presentation, I look at the issue of the Spratly Islands from a historical and comparative perspective, but I focus on the juridical concept of offshore archipelago. I think there's an echo. Okay. No, I focus on that particular juridical concept. And I present here a sample data, and that has to do with the practice of the United States. In 1805, there is an admiralty case about the jurisdiction of a US court over an admiralty incident. And here, the admiralty court recognized the jurisdiction of the US over Mud Islands, which was 5 nautical miles, more than 5 nautical miles from the Mississippi River, on the ground of security, which is reminiscent, and here the Nicaragua case is reminiscent. Now, in 1925 and 1929, the US also proposed that particular conception that groups of islands should have a single belt of maritime zone, therefore an offshore archipelago in effect. And the more important practice of the US in this respect is the 1939 declaration, Panama Declaration, where it adopted a 300 nautical mile safety zone around the American continent itself. Now, in 1992, the US shifted to a position which it has maintained today, that there shall be no offshore archipelago by any continental or archipelagic state. And this is reiterated in 24 in that there is no customary international law as well. But in 2025, the US agreed to a definition of Chagos as an archipelago, which is offshore in nature in the sense that it is beyond 500 nautical miles from Mauritius and even more so from the UK. And so here, it is important to look at the concept of offshore archipelago from a historical perspective and comparative perspective and apply the same to the Spratly Islands. Thank you very much.
好，谢谢梅丽莎·罗亚，这个从非锋的角度啊，阐述了这个离岸群岛啊，对这个离岸群岛的立场主张，也介绍了美国对这个离岸群岛一些看法的演变。谢谢分享。好，下面我们请最后一位华阳海洋研究院中心副研究员包一楠啊。
Thank you, Mr. Moderator. Thank you, Dr. Wu. Today, my topic is characterizing the South China Sea Arbitration Award as a piece of waste paper and unbiased appraisal. We know that ever since the release of the arbitration award 9 years ago, Western governments and scholars having been criticizing the Chinese official position that the arbitral award is a waste of paper, a piece of waste paper. So today I will try to clarify this term and analyze it from two different perspectives. Actually, the term a piece of waste paper is not a term of art. It's a metaphor used by Vice Foreign Minister Liu Zhenmin 1 day after the release of the arbitral award back in July 2016 to re-emphasize and reiterate the Chinese official position that only direct bilateral negotiation between China and the Philippines can eventually solve the disputes between them. It's the only feasible way in Chinese position to solve the disputes. And we have witnessed the chain of reaction and series of escalations over the past 9 years. We witnessed at least 2 rounds of Battle of Nottova Bar. We witnessed encounters between the Chinese Coast Guard and Coast Guard of other nations. We witnessed some standoff at various maritime features over the past 2 years. And it had also generally predicted that there will be a second arbitration against China in the near future. What's more, the ongoing COC negotiations become stagnant thanks to the arbitration award. So, in award, as a mechanism for solving disputes, the arbitration and the award failed completely and miserably. So that's why we need to tear it apart and discuss it into the garbage bin. But from a different point of view, Professor Robert Beckman and Tara Davenport published an article 4 years ago on Straits Times that South China Sea Arbitral Award is not a waste of paper. In my opinion, it is not a piece of waste paper because it has some practical effects to various parties in the South China Sea and beyond. For China, it provides a rare opportunity for boosting academic research on the UNCLOS as well as international law in general. But for the Philippines, the arbitral award became its basis for its further claims in the South China Sea. We witnessed the adoption of domestic legislations last year, as well as the so-called West Philippine Sea Victory Day. For other South China Sea claimants, like the Vietnam, the Malaysia, and Indonesia, somehow the arbitral award gradually became its bargaining chip with China. And it also became their basis for further claims, including their submission to the CLCS, the Extended Continental Shelf. And for other non-regional powers, like the AUKUS, like the Japan and the EU, they frequently use the arbitral award as the pretext to accuse China of violating the so-called rule-based international orders. And it also becomes their basis for further actions, especially the US freedom of navigation operations in the South China Sea. What's more important, according to a US scholar, Isaac Cardam, whose Chinese name is Kong Shihai, in his book, he claimed that the arbitration award became an obstacle to settle disputes via diplomatic methods, because with the arbitration award in hand, both the Philippines and maybe the Vietnam, they are reluctant to solve the disputes with China via diplomatic methods. So, the Chinese proposed methods of direct bilateral negotiation between dispute parties to solve South China Sea disputes become a mission impossible. So my final verdict on the award is as follows. First, the award failed to achieve the inherent goal of settling disputes between China and the Philippines. Rather, it deteriorates the situation in the South China Sea. In this regard, it's a fiasco per se and can be regarded as a piece of waste paper. But on the other hand, it has become a convenient tool for other claimants and non-regional powers to smear the image of China on multilateral platforms. It has become an obstacle to any substantive negotiation between China and other claimants. And it has become a part of history of the South China Sea. Not the beginning of an end, but probably the end of the beginning. In this regard, it will haunt all parties in the region for a long time, like a sword of Damocles hanging above all the state parties of South China Sea. Finally, I want to quote a famous word by our Chairman Mao that if others do not attack us, we will not attack them. But if they do attack us, we will surely strike back. This is also true for legal battles. If the Philippines try to initiate another arbitration against us, we are fully prepared and we can also initiate our own arbitration against the Philippines. That's my personal point of view. Thank you very much.
好，谢谢包一楠啊，这个他分析了为什么南海这个仲裁啊变成了一张废纸啊，这个是当时啊仲裁之后啊刘振民副部长啊就提出这么一张废纸说啊，现在证明这是一张废纸，而且他不仅没解决问题，还这个继续啊。 扰乱是非，挑事生乱，也是当前这个南海问题这个复杂化的一个重要原因吧。所以我们要吸取这个教训，就是要主张要有公正的裁决啊，而不是这种这个霸权的强行的做法。我想今天咱们。 7位啊，已经做了很好的发言，已经超出了一点时间啊，我主持不如这个郑市长有效，我们就缩短这个提问的时间，好吧？因为快到如果大家有提问的，欢迎现在开始。好，梁金德先生。
邀请参加这个会，非常的高兴。今天的这个学习了很多，这个国际上的国内的专家就南海问题发表的这个真知灼见。我提一个问题吧，我刚才听了咱们这一节，咱们这个几个学者讲到这个南海问题，就是我像我坐在旁边的这个萨菲亚女士，我提个问题。 就是南海这个问题啊，这个是最复杂，世界上最复杂，争议的种类最多啊，涉及到的这个参与方也众多的这么一个非常复杂的问题，也是国际社会现在非常热的一个问题。那么这个争议非常复杂，要彻底解决，恐怕也不是短期内也不是很现实。所以我个人认为呢，就是。 搁置争议，共同开发，务实合作，就是解决南海问题的一个必由之路，也是个非常正确的道路。那么这个也有一些进展，就是在这个问题上，中国和有关国家也都正在接触，正在谈判，这个有一些进展。中非之间呢曾经达成过谅解备忘录，但是菲律宾呢现在放弃了，就是本来走在正确的道路上，结果呢，他又放弃了这个正确的道路那么就是令人欣慰的是，这个中国和印尼在这个南海问题上，近期呢有一些良好的进展。2024年11月份，在这个联合声明中，也这个达成了这个共同开发的这个就是共同开发的这样一个共识。 那么我就是想请教一下，从这个中国当然是对这个共同开发，搁置争议共同开发是隶属，也是在积极推进，不管是在 多边领域还是在双边领域，这个希望能够达成，这样的话能够把这个南海问题就能够一个妥善的解决这样一个方法。那么中国和印尼之间达成这样一个共识，那么需要落实。那么从这个法律的角度，还有从这个现实的这个角度，这个是一个，特别是从印尼的这个角度，这个学者们这个考虑如何能够把这个共同开发的这个意向能够落实，能够形成它这个一个现实，这样的话就是让这个南海问题啊，就是让南海变成一个合作、友谊、和平之海。我就问这么一个问题了。
好，阿扁。Yeah.
Can I answer directly? Thank you. Thank you so much, sir, for the question. A very interesting question, and I think very important indeed. I think first thing first, I do think that China, Philippines MOU or agreement is significantly different from Indonesia, China MOU or agreement because the nature of the relationships are very different. And I underline again, I go back to my presentation by saying that Indonesia hasn't changed our position that we are not a claimant state. So our MOU with China that was signed in November 2024 was based on that point of view that we are not a claimant, but we have a very vital interest that the South China Sea remains free of open conflict. And having said that, and also I think also the area which is stipulated in Indonesia's MOU and the Philippines MOU is completely different. The size is different. The nature of the contention is also different. So I don't think it's wise to compare these two agreements because they're not apple to apple. With Indonesia, again, I go back to my presentation, it is our sole interest that everything is managed peacefully. And if resources in the area is the source of contention between any states, that should be addressed peacefully as well. And that I think that is the background of the MOU that was signed in 2024. Having said that, that should also be the base for moving forward. We don't have any yet follow-up from the MOU, so to say, the MOU that was signed in 2024. We don't have a follow-up yet, so we don't have any idea what sort of implementation is possible, what are the plans going forward. We don't have that. But I underline again that Indonesia's position remains the same, that we want to see South China Sea free from any conflict. And if resources are the source of conflict, then that has to be dealt with in a way that is peaceful. And if joint development is one way to go through a conflict-free solution, then that is the way that Indonesia wants to go as well.
好，谢谢Sophia 做这个回答。下面还有谁提问？来，再一个，最后一个啊，我们提完了就吃饭了。
Hi everyone. Thank you very much for a very insightful talk. I'm Ming Wei from the Singapore Embassy, and I've just, from my perspective, my personal perspective, one of the disputes in the South China Sea is really also a dispute over the, the dispute settlement mechanisms that would be appropriate to take. And some countries would like to use negotiations alone, and some countries, have opted for arbitration and so on. One thing I'd be interested in hearing from the panelists is if there's any other mechanisms that would be plausible as another alternative way of settling these disputes or moving towards dispute settlement. For example, under UNCLOS, there's the option of conciliation. I think in the earlier session, Professor Song also mentioned the option of mediation. So I'd be curious to hear anyone's views about this. Thank you very much.
请谁回答？
I'd be, anyone who is a legal expert on this issue, perhaps Prof. Lei, who spoke on ICJ earlier.
好，我们
I think We know that under Article 33 of the United Nations Charter, there are a full range of peaceful settlement of disputes, and the UNCLOS also confirmed that. We know that there are ongoing disputes on maritime pollution between China and the Philippines, and I think inquiry is the preferred method in this regard, because even in the South China Arbitration Award, there are some submissions of the Philippines targeting at the Chinese violating the maritime pollution rules. But actually, we need to verify the facts first, and by using inquiry as the preferred method, we can introduce third-party independent experts to investigate whether there are some what the Chinese or the Philippines argued in this maritime pollution regard. So inquiry, we can use that. And also, Professor Song Yanhui also mentioned the use of the newly established innovative international organization for mediation as a preferred method, although it had not put into function now. But in next year, early next year, maybe it will the organization will put into fully functional, and then we can introduce this mechanism to solve certain types of disputes between China and the Philippines and other dispute parties. For example, the fishery disputes, not highly sensitive disputes like that. And we know that we should not abandon this kind of diplomatic methods like mediation, like inquiry and conciliation, because I oppose the idea that we go polarized. We use the Chinese government currently only stick to negotiation, but and the other disputed parties like the Philippines, they opt for the other end, that is using legal methods, judicial approach, and both prove insufficient and ineffective. So that's why we need to examine whether there are some other middle ground, that is the inquiry and mediation and conciliation that can try to solve this. Do not jump directly to judicial method. I also remember that back in 1978, that the disputes between Argentina and Chile, the Beagle Channel Arbitration Award is also a failure, but it's only after the Pope involved in the mediation that the disputes was finally solved. So we should try that.
好，谢谢依然，那个回答关于这个有什么别的办法啊，更多的方式来调解这个问题啊。现在呢，这个我们那个梅丽莎·罗亚在线上啊，要举手要发言还是要提问？我们给他问一下。喂。
Yes, I need to respond to the question because this is my PhD dissertation as well as my book, and it focuses on the role of non-state actors in negotiating oil and gas cooperation agreements. And this is the experience of China with Vietnam and also with Japan and Korea, although it is in the fisheries area. And here, the value of these types of negotiation is that it becomes less political and becomes purely for economic reasons. The trouble is that with the Philippine experience with GMSU, as well as the Memorandum of Understanding of 2018, is that the process was hijacked by private corporations seeking to improve or seeking to monopolize a large area in the South China Sea. And of course, the governmental agencies on the part of the Philippines opposed that move coming from the Philippine licensee itself. Now, on the part of China, of course, CNOOC was not diligent enough. It did not exercise due diligence in order to prevent that particular hijacking of the negotiation process by the Philippine licensee, a private corporation in that particular case. So there is still much to be done with respect to the negotiations at the corporation level, at the enterprise level, towards an agreement, a modus vivendi among the claimant states at the level of their corporations. Thank you.
好，谢谢。我觉得啊，这个最后这个问题啊很好，就是说，当我们遇到很复杂的问题的时候啊，我们需要创新思维啊，需要想一些别的办法，来活跃丰富我们解决的手段吧。我觉得刚才这个梅丽莎罗亚讲到这个讲到这个非国家行为体发挥什么作用，我觉得这也是可以一个思路吧一个大家可以在座的专家可以多做思考。还有，
听你这样的指示，我看还有很多人可以下午建议下午。
对，因为现在1点多了。
易大使现在一弄我估计这个话题怎么样？你是憋得住吗？憋不住，憋不住才讲。
觉得必须要强调一点宪章联合国宪章第38条，33到38条讲这个争论解决。和平解决，第1条就叫谈判，然后后面跟第7章联系起来，谈判解决是排在第1位的，非谈判解决的方式都带有强制性，方方联合国宪章谈判历史，所以任何属于强制仲裁、提交诉讼都是具有强迫性的，所以在这个问题上不可争议的。所以所谓的这个提交仲裁，是吧？也是和平解决方式，是，但是也不是。如果你查一下联合国宪章33到38条，是不是这样？我就这个说这么一点。
好。言还有。
还有谁？
Maybe very quick. Actually, we do see the legal dispute settlement in the region, like between Thailand and Cambodia, the Preah Vihear Temple case, and which is judged by the ICJ back in the 1960s and also in the 2000s. But very recently, they have a very serious dispute. Only a month ago, a Cambodia soldier died. So to me, I think the most important thing is that both countries, the disputants, have the goodwill and political will to solve the fundamental issue between the two countries. And for that, I think that I want to echo Ambassador Yi's previous comment that I think bilateral negotiations and consultations between disputants is the most important way of settling the dispute and in this region. Thank you.
好，我觉得我们今天讨论会就是这个大家交流沟通，也是一种不是谈判，但是一种沟通，为谈判创造条件，好吧？我觉得上午的这个讨论很有成果，很热烈，时间已经超时了，超时20分钟了啊。好，主持人还有什么？
好，谢谢乐部长，我们把掌声献给乐部长，以及感谢我们的发言嘉宾，谢谢大家。接下来的时间，请大家享用午餐。那我们下午场的环节将于2点半准时开始。那么再次温馨提示一下，因为我们根据发言顺序会对座位进行重新调整，所以请大家带好随身物品。谢谢您的配合。好，我们下午2点半见 ，See you later。
喂，1、2、3、4，喂，我测试一下声音，别的没事啊。喂，1、2、3、4，喂，1、2、3，喂，1、2、3、4，喂，1、2、3、4。1、2、3、4，喂。
谢。